Good evening, everyone, and welcome to the next instalment of the CIPL seminar series. For the students in the room, my face probably isn't too familiar. My name is John Liddicoat. I'm one of the research affiliates, or postdoc, in CIPL. I concentrate on research, which explains why you don't see me around too much. Tonight, it is my pleasure to introduce and to welcome Professor Adelman from George Washington Law School University Law School. Professor Adelman has enjoyed a long and illustrious career. Amongst his many publications include the 9-volume treatise on patent law perspectives, in which he was the sole author from 1988 until 2013. I don't know how you actually managed anything else during that time.
Neither do I.
He's also a co-author in the textbook Cases and Materials in Patent Law. His co-authors on that book included Randall Rader, who at the time was the Chief Judge of the United States Court of Appeals for the Federal Circuit, and in his list of articles includes one on the doctrine of equivalence around the world with Nicholas Pumphrey, who was at the time Lord Justice in the Court of Appeal here in the UK. I should note here, though, after activists and Eli Lilly, you'll have to update that one for the UK.
True.
I could go on with these publications, but everyone here tonight has access to the internet, and you're probably not here to listen to me speak. I should say, though, that Marty comes here tonight after teaching in Munich and Strasbourg. Indeed, he's a little bit of an international man of mystery. I actually met Marty in Cape Town in South Africa. Marty was chairing the session I was due to speak in. The speaker before me started talking about pharmaceutical evergreening. It's a technical but very important part of patent law. And he started speaking about the topic without any reference to empirical data. So between the talks, Marty reminded everyone that there's actually very few instances of evergreening ever occurring. Now, I was listed to speak on standing in patent law, but before my talk, I decided that I should inform everyone that there's actually been some very narrow but specific examples of evergreening occurring in Australia that weren't on Marty's list. I wanted to start my talk, as running behind time is never great. But Marty insisted that talking about evergreening was much more important. So we put standing aside for the next few minutes and in front of everyone had a rigorous yet courteous discussion about pharmaceutical evergreening. Eventually we decided there was probably a discussion best left for lunch. Now, Marty tonight will speak on patent eligibility regarding products of nature and natural laws. This is an area of the law I have a deep interest, and many in CIPL do, and I can see a number of students do as well, which I'm great to see. This is an area of law in which the US and Europe has been diverging. Marty will cast a critical eye on the position in the US, but with an important decision decided here in the UK just a few days ago, he will extend his observation to local issues as well. Afterwards, we'll have time for questions and for rigorous discussions. I think we're in for a treat. So without further ado,
Thank you,
thanks,
John.
Marty.
He didn't tell me how long I should talk. So let's do this. 5 or 10 minutes, that's plenty.
45 to
45, yeah. We will do 5. But here's the key thing. When you go to law school, your main job is to learn how to talk, which means you raise your hand and you ask questions. And so do it. That's why you pay tuition, not to read. And you can read anywhere, but you have to talk. Okay, so I love questions. I don't mind being interrupted at all. And what we'll talk about a little bit today is the United States and what is patent eligible in the United States. But I will focus not on computer programs, which is another issue, but because John's doing some fascinating work and other people here in the biotech area, we'll look mainly at the biotech cases. And actually, this isn't all that complicated. just think of this. The United States is screwed up. If you just get that much, you will be way ahead of our Supreme Court, which isn't very difficult. So let me start by just framing the question. There are many statements in the cases about the law of patent eligibility, and then the court will say, regardless of what Congress said, we have created exemptions. And we want to look now at how those exemptions have been treated by the court. But that's rather remarkable. So in the most important of the modern cases, which isn't Myriad, because Myriad, you almost knew how it would come out after the Supreme Court decided Mayo Collaborative the prior year. I think it was published in 2013. So during that term, and it is the case that brought an earlier case and the way of thinking of an earlier case clearly into the law. But let me first read you what Congress said, and it's simple. Whoever invents or discovers any new and useful process, machine, manufacture, or composition or of matter, or any new and useful improvement thereof, may obtain a patent. That's broader than the European Patent Convention. In fact, you can't get much broader than that. So you say, why are you here and why are you going to bore me tonight? And I say it's because the court didn't stop there. The court said, it's long been held that the provision contains an important implicit exemption. Laws of nature, these are the words, natural phenomenon, and abstract ideas are not patentable. I'll set aside abstract ideas. That's been used by the court because it's unable to define what abstract ideas are in the cases that they talk about as being abstract. You'll say, well, obviously they don't speak English or they speak a different language because they're not abstract. But they've called them abstract, and we'll set those aside. Let's go back to the words for biotech or just medicine. Laws of nature. Well, you might say, why are they saying that? How can you patent the law of nature? By definition, it's old. Name me a new law of nature. You can't. At least I can. So maybe you can. But even at Cambridge, where Isaac Newton worked, James Clerk Maxwell, where the Laboratory of Molecular Biology is a Nobel Prize factory, I don't think you can explain to me some law of nature that's old. That's not old. So patents deal with new stuff. That's the fundamental doctrine of patent law. You have to have something that's new. So why are they saying that? I really don't know. I know they don't know. They just quote, I said it 100 years ago, 150 years ago, we said it. I don't know. But I know that the ones they talk about are old. For example, the law of gravity. Now, maybe they never recognized that things do fall down. But if they had, they'd know it's old. Or maybe if they looked at the planets and saw that they moved in elliptical, and not quite elliptical orbits, they would know that gravity was old and obviously, therefore, not patentable. Then they say phenomenon, natural phenomenon. Okay, natural phenomenon, maybe a natural product. You find some natural product. You can't patent that. It's old. Natural phenomenon, by definition, it's old. When you read it, you have to say, either I wasn't educated or they aren't educated. You can make up your mind. They all went to Harvard. Now, they didn't go to Cambridge, so that's important to note, but they went to Harvard or Yale. But they say that. Then they go on in this paragraph, and this is as good as any from the Mayo case, to talk about that something has to be discovered really beyond these laws of nature, and they refer to the Funk Brothers case, although only through the case of Chakrabarty. It's rather surprising that they did not talk about Funk Brothers specifically. In Myriad, which came the next year, they do, and specifically focus on Funk Brothers. But there is something that ought to be somewhat interesting to you in the case. They talk about an old English case which has been repeatedly mentioned in Supreme Court cases, going way back, never determinative, but it's now cited here, although I'd say it's now miscited here, and it is the hot blast case. Going way back, Nielsen versus Hartford, but Nielsen, if you have looked at old English cases, you want to look at the Nielsen cases, because it was, some say, the most important invention of the Industrial Revolution that involved the making of iron. And basically, the invention was upheld by the English courts. Fortunes were paid in license fees. And it was this simple but revolutionary idea that when you were making iron in a pot, so going from iron oxide and putting all this stuff in and heating it up, they would just take air. And of course, you need oxygen for the reactions. You just take air. The discovery was if you heat up the air, which takes energy, but you get much of it back. In fact, you get all of it back, and the total amount of energy goes down. The total amount that you use goes down. This was a revolutionary discovery. Now, the patent just had some method, a common method of heating something, and it had a separate little boiler or some kind of unit that you heated up the air. But you could do it anyway. And there was no invention in going from the principle, the teaching, that you should use hot air rather than cool air. If I told you to do it, you'd go ahead and do it. I don't know exactly which way you do it. There are 20 different ways, probably, of doing it, and you'd be fine. And that was upheld by the courts. However, the Supreme Court of the United States in 2013 interpreted it as requiring an inventive step going from the principle. In other words, I tell you the principle, and unless you have to make an invention to heat up the air, it's not patentable. And it's really surprising. And it's really surprising that nobody sat down and looked, well, how are the English courts interpreting this case today? No, nothing like that. I can't really explain it. Beyond which they had already made up their mind. And I know that's true. That Mr. Justice Breyer, who wrote the opinion, had already made up his mind, and he got the court to go along. And you say, well, don't some of these people think? Well, we don't have evidence of that. It's rather surprising. Now you got to know something about Mr. Justice Breyer, and then we'll move on. But it is interesting. Mr. Justice Breyer is the first person to actually have to write an article to get tenure at Harvard Law School. In the old days, it was, oh, they're brilliant. They were a brilliant student. That's enough. Or maybe they're charming. I don't know. But they didn't have to write a paper. Breyer, Stephen Breyer, is the first one that did. And you should go read it. Calls it the uneasy case for copyright. 1970, about 1970 in the Harvard Law Review. He got tenure. Too bad he didn't stay there, but that's another story. But when he got tenure from this paper, which I think demonstrates an aversion to intellectual property. Maybe you'd agree with it. You can go, you can look. It's an interesting paper. I know from a private conversation that a federal judge told me about that he has fundamentally no use for patents. That may give you some background as to this field. Comes the next year and we get Myriad. But before I talk about Myriad and genes, let me talk about a case which I think was the key case in moving the court from essentially the views of the English courts that, well, okay, you can't patent a principle, but once you have a practical application, you can patent the practical application. And you'll find that statement even in Kieran Amgen from Lord Hoffman. But that was the law in the United States. At least when you look at the old cases, that's what it seems to be. You don't find a case that says, okay, the discovery, let's treat that as prior art. So show me, after you've made the discovery, which you get no credit for, did you then take that discovery and make something that we'll call an invention? The first case that I think does that is a fascinating old case called Funk Brothers. It was decided in 1948, and the opinion is written by Mr. Justice Douglas, who was a highly intelligent man with, in my view, a great propensity for error. And he got this case, and you can, if you're all farmers, any farmer here? I never have a farmer in my classes. No farmers here. 100 years ago, I would have a lot of farmers, but not now. Okay. Do you ever hear of root bacteria or nitrogen-fixing bacteria? She knows. I can see. She knows. Certain plants called legumes, and we won't go into it, but there are a bunch of plants that are called legumes. And you can grow them in nitrogen-deficient soil if you infect their roots with root bacteria, because those bacteria then can convert the nitrogen in the air into nitrogen compounds, which are essential for life. If you didn't have nitrogen compounds, we wouldn't be. That's simply the fact. So here was the problem. Every one of the legumes required a different root bacteria. And when you treat the seeds, you surround it with these bacteria, so you'd infect the seeds, and a farmer had to have different root bacteria for each of the legumes that the farmer wanted to plant, and it was a problem. So you say, well, put them together, put those bacteria together and just use it. Well, no, because the bacteria would interfere with each other. Each one of those bacteria was a different species of a genus of bacteria, a class of bacteria called root bacteria, and then species, and then below species you have strains, slight differences. And so nobody did this, and it was a problem for farmers because the bacteria would interact. So you had to keep them separate, and the farmers viewed this all as a pain. So this Bond, the inventor, was given the job. See if you can figure out a way to do it. And he studied the situation, and he discovered that within the species, there were certain strains, not many, but certain strains that you could mix together, and they would not interact. And therefore, you could have one product that the farmer could use on all the different seeds that he or she was planting. And this became a great success. And he teaches it all, and it's an interesting patent to read, the Bond patent 2200532 from 1940. And it's a detailed discussion of more than you probably want to know about legumes and how to farm them and bacteria, but important. The case, the trial court said it's just a discovery. The Court of Appeals said, no. I mean, this is a practical product. Yes, he discovered certain properties of specific strains of the various species, but he made a practical product, which is essentially what the English courts held in the Nielsen case, and which the US courts had held up till 1948. Goes to the Supreme Court. Now, at this time, we're talking about a court that was essentially the Roosevelt court. There were some conservatives on the court, relative conservatives on the court, but it was basically the Roosevelt court. One had been appointed by President Truman, but that was it. It's a totally democratic court, and they reflected the anti-patent bias of the late 1930s. It was fairly strong, and the bias was so bad that Mr. Justice Jackson, who was on the court and dissented in this case, he said in a case right around this time, the only valid patent in the United States is one that the Supreme Court hasn't gotten its hands on. He was absolutely right. And it, just an aside, because some of the stuff's interesting, Mr. Justice Jackson was the chief American prosecutor at Nuremberg. And if you read the Doctrine of Equivalence case from 1950, compare it in some ways to the recent case on the Olympia case in the Supreme Court of the UK, Jackson uses hotter language, but they basically come to the same conclusion. That was Jackson. He was plucked out of the Supreme Court in 1946. Truman told him, get on a plane. Imagine telling a judge on the Supreme Court, you get on a plane, you go over to Nuremberg, you are going to be the chief American prosecutor. And he was. He did a great job with Hermann Goering, except, I shouldn't get off on this, but it's funny. He couldn't cross-examine anybody. He asked broad questions. Goering was smart, and he took Jackson to the cleaners. Finally, they took Jackson away, and they brought the British prosecutor, who I think got a third at Oxford. I mean, he was at the bottom of his class, right at the bottom, except for one thing. He worked 24 hours a day, and he piled up all the papers they had, and he destroyed Goering. So Jackson, not a very good cross-examiner, but great opening and closing statements, classics. So this is what Jackson said, 1948. The only, maybe it was 49, the Youngerson case, the only valid patent is one Supreme Court hasn't gotten its hands on. So Bond is written by Mr. Justice Douglas. And for the first time, we get, you have to do more than something that's practical with the scientific discovery. It was a discovery that you could mix certain strains and the bacteria would not interfere. There's no question that was a discovery. And then he put it to practical use, which was a practical product. Now, there were fundamentally three dissenters in the case, one, Felix Frankfurter, he dissented because you could argue it was a concurrence, but they all agreed that there was an invention there. So it was 6-3. That case really was mentioned in a computer case, Benson and Tabbitt, in the 1970s, again by maybe it was 1960, by Mr. Justice Douglas. But it was not widely discussed. It was picked up by Mr. Justice Stevens in a case, Parker versus Fluke, which is again a computer-related or calculating case. But he picked up this idea that if it involves an exemption, then the exemption is really prior art. If you discovered something, you got no credit for it. What did you do thereafter? And we'll look to see if what you did thereafter would give you a patent. So that's 1977. To confuse students and people, things changed a little bit in 1980. And there is a case called Diamond versus Deere, which did not apply that methodology in 1980. Also, in 1980, the Supreme Court, 5-4, it was always 5-4, decided that life forms are patentable, 1980. And in the patent misuse area, which is another flashpoint, the Supreme Court, 5-4, decided in favor of the patent owner. So you could ask, well, what happened in 1980? Why, for a moment, there seemed to be a shift in the court, albeit 5-4. One theory, at least former Chief Judge Rader believes this strongly, is at this time, Congress was considering the bill that ultimately led to the creation of the Court of Appeals for the Federal Circuit. And that the Supreme Court may have felt, let's back off here. Congress is not happy with what we're doing. It was perfectly clear that Congress created the Court of Appeals for the Federal Circuit in part because it didn't like what the Supreme Court was doing. There's more to it. But you understand that was a revolution. In American judicial history, we've never taken a field of law in the federal system and assigned a particular court to it. A major field of law. In fact, one that's in the Constitution. Not many are in the Constitution. Patents and copyrights are in the Constitution. And that was taken from the circuit courts and given to a monopoly court. And it became a very powerful court. There's a whole subsequent history. So, in the early years of the Federal Circuit, you never heard about Funk Brothers. You didn't hear about anti-patent doctrines. You heard a lot about pro-patent doctrines. I mean, the Federal Circuit saw its mission to strengthen the patent system. That was the mission of the first Chief Judge of the court, Howard T. Markey. His name is on the building. We could talk about that. It's a fascinating story in and of itself. So, but now, 2013, the Supreme Court is back. They forgot about what happened in 1980. It's a whole new court. All those people are dead. They're gone. Maybe Mr. Justice Steve, he's still alive. He's 97, 96. And he's off the court. He's still in good shape, actually. But most are gone. So I always looked at cases like Funk Brothers very naively. I said, well, doesn't make any sense. And the Federal Circuit isn't following it. So, not harmful. One of my colleagues, who's now moved on to the University of Virginia, John Duffy, is a terrific scholar, and somewhat obsessed with the Supreme Court, because he clerked for the Supreme Court, and so he's obsessed with the Supreme Court. I thought he was obsessed. He's been right every time, and I've been wrong. And he said, no, they only look at their old precedents. No, they don't think. No, don't think they think. They don't think. They look at their old precedents. You have to understand that. This, I admit, he was right. So, come now the new generation on the court. They look at their old precedents. What do they find? Funk Brothers. So, you can read Mayo and say, well, what's the difference? Well, there isn't any, really. Mayo involves an old drug, quite an old drug, thiopurines. Thiopurines is class, to treat inflammatory bowel disease, which Sue can tell you is not a good thing to have. It's bad. So, but the drug, and even in the opinion, he admits it, has never been that successful. Either it's too strong or too weak. And you have to think of these cases like this. Let's assume that the doctor who got the patent made a Nobel Prize type discovery. So you've got to clear your mind of notions. Was it really a big deal or not? Assume it was a big deal, just in your analysis. Assume that all of a sudden this old drug became a very valuable drug, and people who suffered severely with inflammatory bowel disease now felt a lot better. I wish it were true. It's not quite true. It's not, it would be nice if it were true. But from a legal analysis, if I'm teaching my class, I say, assume it's a Nobel Prize, one of those where they come up with it and the next year the Nobel Committee meets and says that we have to give a Nobel Prize for. There's no question about it. So what they had come up with is you do specific blood tests and you measure the metabolites. And then they taught you if you keep the metabolite within a particular range, it really works quite well. But if you let it get out, it does not work well. So assume that was, wow, why didn't we think of that before? We should have thought of that before. Well, once I tell you that, I know you can easily say, well, I know how I can use that discovery. That's how I'll treat patients. I will have them tested, maybe constantly, maybe monitored, and they're going to be much better. And that's basically what the claims were. So Mr. Justice Breyer goes on and on, but basically that's what they said. It doesn't matter because all they did once the scientific discovery was made is do what was obvious. Fair enough. I mean, they did what was obvious. So you have to judge the discovery. That sets the stage for myriad. Now, what do we have with myriad? I'm sure many of you know, well, just let's make this simple. That the only gene we're talking about is the breast cancer 1 gene. There are 2 different genes, but I don't see as a matter of legal thinking that there's any difference between one and the other. Let's just say I've got a gene. We know there's a gene. Everybody knows there's a gene. We've done all these studies, and not only do we know there's this gene, which we really want to find, because we don't know anything about it, but we do know that if a woman has that gene, the chances, lifetime chances of having breast cancer is almost 4 out of 5. But worse than that, that's bad enough. The lifetime chances of ovarian cancer, which is much harder to detect, goes way up. So you want to find the gene. They couldn't find it. They knew it was on chromosome 17. They were within about 1 million base pairs. They knew it was somewhere there, but they couldn't find it. So Myriad finds it. Now let's assume that the next year they got a Nobel Prize for that, for finding it. Just assume, because it doesn't change the legal analysis. So it was really an important discovery. You can argue, people have argued, no, others could have found it. No. Forget that. Assume the Nobel Prize. Right away. We've been looking for that gene for 5 years. We can save all kinds of people if we only have the gene. Once we have the gene, we can check for mutations. We got technology to do all that. So what we need is the gene. Actually, what we need is just knowing the nucleic acids for the base pairs. But that doesn't matter. We need the gene. Now, that isn't the first case where that was really necessary. I'm sure all of you have read Lord Hoffman's Kirin Amgen case, where they talk about the erythropoietin gene and the finding of that gene. How many have read that case? You actually should. I know he's read it. I know you've read it. He's going to find the U.S. out of compliance, I know. That was the actually doctrine of equivalence case that sort of got overturned in the All-INTA case just recently by the Supreme Court. But in that case, the whole idea was to find the gene for erythropoietin. And it's a critical gene because before that, if you had any kind of kidney failure, any kind of problem, you wouldn't, the body makes a little bit of erythropoietin, and that stimulates the manufacture of red blood cells. So you don't have that, you have kidney failure, you're in bad shape. Really bad shape. Also, if you really want to cheat athletically, you may want to create a few extra blood cells. I'm not recommending this, but it is used or misused for that purpose. In the early days of biotechnology, people were looking for this gene, and Amgen found it. And all Amgen did afterwards is put it in a standard cell, a cell line that was well known to researchers. And from that point, they were able to make from bacteria erythropoietin. I should say the bacteria were kind enough to work hard for people. They don't have human rights. Maybe there's bacterial rights or something. But that's what they did. And we've been much better off ever since. That's the foundation of the Amgen Corporation in Thousand Oaks, California. I sometimes wonder whether the Supreme Court has any idea what it's doing. Because some of our industry would be wiped out with the rigorous application of this idea. But back to Mr. Justice Thomas this time. He goes through a discussion, discusses and applies Funk Brothers, and says, yes, this was a discovery. But once you made the discovery, the rest was pretty routine. Well, he was right about that. The whole key was the discovery. Just like the whole key was the discovery of the erythropoietin gene. And there are a whole bunch of gene cases. I just picked the erythropoietin case because it was the subject of the Kieran Amgen case in 2004 in the old House of Lords, which is the court of final authority. Now, the issue was not the patentability. In that case, nobody questioned that. The issue was infringement, and that's a different issue. So you look at Mr. Justice Thomas's opinion, it could come right out of Funk Brothers. So now I see clearly that my former colleague, John Duffy, is absolutely right. They just apply their old cases. And it's Funk Brothers. Well, let's test that a little bit. Let's take a decision that just about everybody admits is kind of dumb. And that's Kimball versus Marvell. It's an interesting one to read. Recent decision of the Supreme Court. And it was a split decision. Not everybody agreed with it, but the court looked at a 1964 case that it really is dumb. I mean, it said that it was a rule of patent law that you can't enter into this kind of contract. You are a licensee. I have the patent. You say to me, Adelman, I like your patent, but I don't have a lot of money. I don't know whether this is going to be successful. So here's the deal. I will pay you for 20 years. Now your patent only goes for 10, but I'll pay you for 20. But keep that royalty down so that I can see if I can really develop this product. I say, well, I'd like a higher rate, but, maybe that's the best deal I can get. And I say, okay, you pay me for 20 years and kind of we share the risk that this thing will be successful. That was Brulette versus Tice, 1964. Supreme Court without much thinking. Again, Mr. Justice Douglas. Remember, he had a high IQ. He says, no, patent policy. You are collecting royalties after the patent expires. Horror of horrors. Isn't that terrible? I can't see why it's terrible, I mean, but he says it. Only one dissenter. Surprising, it's John Marshall Harlan. Now, when you see John Marshall Harlan dissenting, you almost know John Marshall Harlan is right. And moreover, it's one of the great names in American law, John Marshall Harlan, because in 1896, his grandfather dissented in the great case of Plessy versus Ferguson, where the Supreme Court shamefully said that separate but equal was okay under the US Constitution. If you want to read a great opinion, you read John Marshall Harlan the first in talking about this kind of segregation, and he just destroyed it as far as I'm concerned. So in my mind, it's a great name in American law. When I see John Marshall Harlan, I read it, and I almost always agree with him. And I think he was absolutely right. But that's 1964. So here we're 50 years later. Now by that time, everybody has written, this is stupid. And the Supreme Court sort of says it's stupid because it says, why are you so excited? Here's how to avoid it anyhow. Here's the way to get around it. So what's the big deal? And besides, we always stick with our cases. And if Congress wants to change it, they can. Which is the dumbest thing you can possibly say. Sure they can. You can't get the Congress to do anything. As Donald Trump is finding out. And you should think like this. It's incredible. But they put it down. There were 3 dissenters who said, come on, this rule is so stupid, we've got to change it. But there you have it. That's my explanation. And so when some country brings an action in the WTO that the United States is violating TRIPS, I would support that view. He's going to do it. Okay, I think probably kept you too long. John, you want to take questions?
Okay, I'd like to thank Marty for that.